Let's turn to Lesson 35, which addresses the question, how have civil rights movements resulted in fundamental political and social change in the United States? And I'll start by asking you this question. What was the status of civil rights in mid-20th century America?
The status of civil rights was in flux in mid-20th century America because the 14th Amendment was ratified in 1868. The 14th Amendment says that no state shall deny to any person within its jurisdiction equal protection of the law. But what does equal protection mean? That was left up to the states. So we have segregation by state law throughout most of the United States, and that includes public transportation and, of course, public education and voting rights. When we moved to the mid-20th century, a political and social movement called the Civil Rights Movement changed America's laws indirectly by putting pressure on state governments and the national government to regularize the treatment of certain groups.
You mentioned segregation. Can you describe the difference between de jure and de facto segregation?
De jure segregation is done by law. So that would mean at a local level, even a school board level, that the races are separated according to the rules of that community. And of course, that can also go up to the state government and the federal government. De facto segregation means by circumstance or by fact. So what we have today is de facto segregation, much more commonly than de jure segregation. So if people are segregated by economic circumstances into different neighborhoods, then they will go to different schools if they have a neighborhood school system. That's an example of de facto segregation today.
I think we're all familiar with the Brown v. Board of Education decision. Can you address the impediments that limited the effect of that decision?
Well, the Supreme Court has the power of judicial review, which we will talk about later today. But the Supreme Court has no enforcement power. And the Federalist Papers, especially Federalist Paper number 78, talks about the limitations of the court's power as being a positive check on the court. So the Supreme Court, when it rules on something, according to Federalist 78, it has only judgment. It does not have the purse or the sword of the community. So in reality, what that means is that different parts of the political system have to actually enforce a court's decision. Those parts can include the president and the federal bureaucracy, the Congress by law and appropriating money, and in the case of segregation, the states. The states, especially southern states, but not exclusively, they resisted the court's order, not just in the Brown case, but in subsequent federal decisions regarding desegregation and busing, and again, that includes the North as well. If the cities and the states and the politicians are not going to be interested in supporting these decisions, and if the communities resist, they will not be enforced.